Bangun. Kes BI Sempang A72 NCVC Sempang 11 Sempang 02 Palang 2026 bagi pihak pemohon Nur Fadila binti Ahmad Saikin dan bagi pihak responden Caib bin Basirun dan lain-lain. Mahkamah merekodkan bahawa pihak-pihak telah bersetuju terhadap fakta material berikut. Pemohon telah dipilih dan diberikan jawatan sebagai guru sandaran tidak terlatih oleh pihak responden. Penempatan tersebut kemudian ditarik balik setelah responden dimaklumkan bahawa pemohon sedang hamil. Fakta-fakta ini adalah tidak dipertikaikan.
Dengan izin Yang Aris, saya HAIRIL Iskandar bagi pihak pemohon berhujah bahawa penarikan balik tawaran tersebut adalah berasaskan kehamilan dan seterusnya merupakan diskriminasi jantina yang melanggar perkara 8 Fasal 2 Perlembagaan Persekutuan Malaysia.
Dengan izin Yang Arif Puan, saya RABI'ATUL ADAWIYAH bagi pihak responden ingin mengakui penarikan balik tersebut, namun ia ingin menegaskan bahawa ia dibuat atas pertimbangan pentadbiran berhubung keupayaan pemohon untuk berkhidmat secara berterusan dan bukan atas dasar diskriminasi jantina.
Yang Arif Puan, dengan izin mahkamah, pihak pemohon dengan hormat memohon agar prosiding ini diteruskan dalam bahasa Inggeris memandangkan hujahan dan autoriti yang akan dirujuk sebahagian besarnya adalah dalam bahasa Inggeris.
Adakah pihak responden mempunyai sebarang bantahan?
Tiada bantahan Yang Arif.
Baik, permohonan dibenarkan, prosiding akan diteruskan dalam bahasa Inggeris.
Izin Yang Arif Puan, this case raises a significant constitutional question whether the refusal to employ a pregnant woman amounts to gender discrimination under Article 8 Clause 2 of the Federal Constitution. It further invites the court to consider whether international convention, in particular the Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, may be referred to in interpreting the scope of equality and non-discrimination guarantee under Article 8 Clause 2. This case is not merely about employment. It concerns dignity, equality, and whether a woman in Malaysia can be denied an opportunity solely because she is pregnant. Yang Arif Puan, this is a clear breach of the Federal Constitution. The applicant was denied employment for one reason and one reason only, her pregnancy. Therefore, there was no issue as to her qualification or ability. Pregnancy is unique to women. To penalize it is to discriminate on the ground of gender. Such treatment strikes at the very core of the constitutional equality and cannot be justified on any administrative basis. Yang Arif Puan, pregnancy is inseparable from being a woman. It is not a neutral condition. It is one that only women can experience. Therefore, to disadvantage a person on the basis of pregnancy is, in substance, to discriminate against her because of her gender. To hold otherwise would allow discrimination to be justified under a different label, which would defeat the protection guaranteed under Federal Constitution. Yang Arif Puan, Malaysia is a party of the CEDAW, and CEDAW makes it clear that discrimination arising from pregnancy is unlawful. Although not directly incorporated, it serves as a persuasive guide in interpreting Federal Constitution, reinforcing a strong and purposive protection against gender discrimination. The respondent, represented by Puan Adawiyah, attempt to justify their actions on the basis that the applicant may be absent or unable to perform fully. However, Yang Arif Puan, this justification is unsustainable. First, the position was on month-to-month basis. Second, any employee, pregnant or not, could leave at any time. And third, yet pregnancy alone was singled out. This amounts to unequal and discriminatory treatment. Yang Arif Puan, the position is clear and compelling. The applicant was qualified. She was accepted. She became unfit only upon disclosing her pregnancy. There was no change in her qualification, no change in her ability, only her pregnancy. This demonstrates that the respondent's decision was based solely on pregnancy, which is inseparable from gender. to penalize pregnancy is in truth to penalize a woman for being a woman. This position is further strengthened by Malaysian obligation under the CEDAW, which makes it clear that any disadvantages arising from pregnancy constitute a discrimination against women. In light of this, Yang Arif Puan, we respectfully submit that this is not a borderline case. It is a clear case of discrimination. The applicant was treated differently for a reason only applies to women. Such treatment strikes at the very core of equality guaranteed under Federal Constitution. It cannot be justified by administrative convenience and it cannot be excused as policy. To allow such reasoning would be to permit discrimination in another form. Further, it stands in direct conflict with Malaysia's obligation under CEDAW, which affirms that pregnancy-based discrimination has no place in employment. Accordingly, we humbly submit that the respondents' actions are unconstitutional and we pray that this Honourable Court uphold the Constitution and grant justice to the applicant. That's all, Yang Arif Puan. The applicants rest our case.
Counsel for the respondent, you may now proceed.
Much obliged, my lord. So, my learned friend has framed this case as one of constitutional injustice. However, with respect, the respondents submit that this characterization is legally unsustainable when the facts and the applicable law are properly examined. My lord, the respondent case rely on three principal grounds. First of all, the absence of any legal right on the part of the applicant. And the second one is the administrative and policy basis of the decisions. And lastly, the inapplicability of Article 8 Clause 2 in the present circumstances. First of all, my lord, the respondents submit that there was no binding contract of employment between the applicant and the respondent. As clearly established, the position of Guru Sandaran Tidak Terlatih or GSTT is temporary in nature, engaged on a month-to-month basis and may be terminated at any time as said by the applicant. So therefore, the applicant had not acquired any legal right or status to the position. In fact, the respondent have expressly contended that in the absence of a binding contract, the applicant lacks the necessary locus standi to bring this action. The applicant had no legal right to demand employment. Your Honour, the respondent decision must be viewed within the context of administrative policy and practical necessity. The Ministry had provided us a clear justification for not employing pregnant candidates in this role. The first one is because the period required for recovery after childbirth and the likelihood of frequent absence due to health reasons. Third one is the need to replace the teacher during such absence and the inability of the GSTT system to accommodate replacement teachers. Now, these factors were not arbitrary but directly related to the operational objective of the GSTT scheme, which is to address the urgent shortage of teachers in schools. This will not only affect the administration but also the students. My lord, the respondents submit that this was not a punitive measure against pregnancy but a practical response to ensure continuity in education. The focus was not on the applicant gender but on the feasibility of fulfilling the role effectively. Yang Arif, it is also the respondent position that this matter involved a policy decision which ought not to be interfered with by the court. The respondent rely on established authorities to submit that court should exercise judicial restraint in reviewing administrative and policy decisions, particularly in matter involving public service and education. Yang Arif Puan Hakim, the decision of this nature involve consideration of resource allocation, administrative efficiency, and public interest. These are matters best left to the executive, not the judiciary. My lord, the respondent further submit that the distinction made in this case is based on reasonable classification. The differentiation is not between men and women generally, but between candidates who are able to immediately and continuously perform their duties, and those who may not be able to do so. As such, the classification is basically based on functional capability and not gender. My Lord, the respondent also rely on the Federal Court decision in Beatrice Fernandez and Sistem Penerbangan Malaysia. So the principle established is that Article 8 of the Federal Constitution applies where there is discrimination by the state in the exercise of public law powers and not in purely contractual or employment matters. In the present case, the applicant is attempting to elevate an administrative employment decision into a constitutional claim. With respect, such an approach is inconsistent with established constitutional principles. My Lord, the applicant has also relied on international instruments such as the CEDAW, and the respondent do not dispute its importance. However, we contend that such conventions, while persuasive, do not automatically confer enforceable right unless clearly incorporated into domestic law. In the present case, the issue remains one of administrative discretion rather than a breach of a constitutional guarantee. My Lord, in light of the above, the respondent respectfully submit that the applicant had no legal right to the position. The decision was made pursuant to legitimate administrative consideration. It was grounded in policy and practical necessity, and it does not amount to discrimination within the meaning of Article 8, Clause 2. Accordingly, we respectfully pray that the applicant claim can be dismissed. That are all from the respondent side. Thank you.
Before you proceed further, counsel for the respondent, you submit this that this is not a case of discrimination. However, I must ask, could a man ever be rejected on the basis of being pregnant?
My Lord, biologically, no.
Then, counsel, how can this not amount to distinction based on gender?
My Lord, it is true that pregnancy is unique to women. However, the respondents submit that the decision was not based on gender per se, but on the anticipated impact on service delivery. The concern was whether the applicant would be able to fulfill the continuous and immediate requirements of the position. Therefore, the distinction is based on operational practicality, not gender discrimination.
Counsel for the applicant, are you suggesting that any disadvantages arising from the pregnancy is automatically unconstitutional?
Yes, Yang Arif Puan. Pregnancy is a condition that is inherently and exclusively linked to women. Accordingly, any adverse treatment arising from pregnancy constitutes discrimination on the ground of gender.
Counsel for the applicant, to what extent that the court can rely on CEDAW in interpreting Federal Constitution of Malaysia, given that it is not have been fully incorporated in domestic law?
Yes, Yang Arif Puan. While CEDAW is not directly incorporated into domestic law, it is respectfully submitted that this honourable court may rely on it as persuasive interpretive aid. In interpreting Article 8, Clause 2, particularly on gender equality, CEDAW assists the court in adopting a purposive and progressive approach consistent with Malaysia's international obligation without overriding domestic law.
My Lord, my learned friend suggests that any disadvantage linked to pregnancy automatically constitutes discrimination. With respect, the respondents submit that such an interpretation is too broad. If accepted, it would effectively prevent public authorities from making practical and necessary administrative decisions, even when they are made in good faith and in the public interest. The respondent believes that the law must allow room for reasonable administrative judgment, particularly in sectors such as education.
Counsel for the applicant, do you have any reply on that?
Yang Arif Puan, the respondent is in substance attempting to relabel discrimination as policy. However, the legal position is clear. Federal Constitution expressly prohibits discrimination on the ground of gender. Once such discrimination is established, it cannot be justified under any purported administrative or policy-based reasoning.
If there are no further submission, the court will now deliver its decision. This court has carefully considered the submission made by both parties. The issue before the court is a straightforward but important one, whether a woman may be denied employment simply because she is pregnant. And the court answered this in negative. Pregnancy is a condition that is unique to women. For that reason, any adverse treatment based on pregnancy is in substance discrimination on the ground of gender. And also, Federal Constitution of Malaysia clearly prohibits discrimination on the ground of gender. This protection is constitutional in nature and cannot be displaced by administrative convenience or political considerations. The respondents argue that the decision was based on administrative concern, but particularly the ability of the applicant to perform her duties continuously. However, this court finds that such justification cannot stand, as it still results in differential treatment based on pregnancy. And this court also take note that Malaysians' obligation under the CEDAW, although the CEDAW is not directly incorporated in domestic law, but it may be referred as a persuasive guide in interpreting constitutional right. And it enforces the principle that discrimination against women, including pregnancy-based discrimination, is not acceptable. And accordingly, this court finds that with the withdrawal of the applicant's appointment was discriminatory in nature and it breached the Article 8 Clause 2 of Federal Constitution. Therefore, this is unconstitutional and void. The applicant's claim is allowed. There will be no order as to cause. So, court is adjourned. Bangun.